Good afternoon and welcome to the American Constitution Society's annual Supreme Court preview. I'm Russ Feingold, the president of ACS, the country's foremost progressive legal network with more than 200 student and lawyer chapters across the country. ACS's mission is to shape legal debate, nurture the next generation of lawyers and judges and advocates, and ensure that the law is a force to improve the lives of all people. If you aren't already, I'd encourage you to become a member of ACS. Go to acslaw.org, where you can join ACS and find more information about events like this one. I'd also like to encourage you to follow ACS on our social media, including on Twitter at ACS Law. Just some quick housekeeping notes before we begin. Today's discussion is being recorded and the recording will be available on ACS's website after today's program concludes. 1.5 hours of California CLE credit is available for today's discussion. Additional CLE information will be shared with all participants in a follow-up email. There will be time at the end of today's discussion for audience questions. To submit a question, please use the Q&A box at the bottom of the Zoom screen. Do not use the chat to ask your questions, as we will not be monitoring it and your question will not be put in the queue. If you're a member of the press asking a question, please identify the outlet for which you're reporting at the top of your question. Now, let me turn to today's discussion. I don't think it's hyperbolic to say that the most recent Supreme Court term's effect on our laws in our country was seismic. With a 2/3 conservative supermajority of justices ensconced on the court, the conservative legal project wasted no time. In its first full term, the conservative supermajority completely dismantled a half-century of precedent around the fundamental right of a person to choose to have an abortion. It expanded the fantastical reading of U.S. legal and constitutional history to further restrict the ability of states to address the nation's epidemic of gun violence. These were just two of the most high-profile, but by no means the only victories for the conservative legal project. And so our attention, of course, now has to turn to the new term that begins in just a few days. What can we expect from this court, which welcomes its first ever Black woman justice, Ketanji Brown Jackson, but retains its 6-3 conservative supermajority? What cases has the court chosen to hear this term? And does that say anything about the direction the court is headed? To help lead our panelists in considering these questions, it's my great pleasure to introduce our moderator, New York Times Supreme Court correspondent, Adam Liptak. In addition to covering the Supreme Court, Adam writes Sidebar, a column on legal developments. A graduate of Yale Law School, he practiced law for 14 years before joining the New York Times news staff in 2002. He was a finalist for the 2009 Pulitzer Prize in explanatory reporting. He has taught courses on the Supreme Court and the First Amendment at several law schools, including Yale and the University of Chicago. As you can see, we're in very good hands with Adam leading today's important discussion. Adam?
Thank you, Russ. And as you were saying, we just came out of a tumultuous term. You might think the court would be inclined to take a breather. Sometimes it does. Sometimes the follow-on term to a big term is sleepy. That is not the case this time around. We are heading into another big term with the potential to transform American life, with cases on race, voting, religion, LGBTQ rights, and immigration. And ACS has assembled an all-star cast to give us an overview and a preview of what to expect. Let me introduce the panelists in the order they're going to speak. I've encouraged the panelists, in addition to their presentations, to feel free to mix it up, to give us some perspectives and comments and reactions to what's going on in this extraordinary moment at the Supreme Court. I may ask the occasional question, and as Russ said, we've put aside time at the end for the audience's questions, which you should please put in the Q&A. So we will hear first from Deborah Archer, who's president of the American Civil Liberties Union and professor of clinical law and co-faculty director of the Center on Race, Inequality, and Law at NYU Law School. Then Jonathan Diaz, senior legal counsel at Campaign Legal Center, Kent Greenfield, who's professor and dean's distinguished scholar at Boston College School of Law, Winona Single, associate professor of law and director of the Indigenous Law and Policy Center at Michigan State University College of Law, and then Shobha Sivaparsad Wadja, who's associate dean for diversity, equity, and inclusion, and the Samuel Weiss faculty scholar and clinical professor of law at Penn State Law. Probably the biggest case of the new term, and one with the potential to undo significant precedents, concerns race-conscious admissions in higher education. And I'll invite Deborah to tell us a little bit more about those cases.
Yeah, thank you. And thank you to ACS for inviting me to participate. I wish I had a more promising case to talk about, but here we are. And it may feel like we've been here before. I think it's because we have. The Supreme Court has held for more than 40 years that race is an important and permissible consideration among many factors within a holistic higher education admissions process. And the two cases, Students for Fair Admissions against Harvard and against UNC Chapel Hill, really threatened to upend that. Starting with Bakke in 1978, which declared that although you can't remedy societal discrimination with race-conscious admissions programs, you could protect the benefits of diversity in higher education. And the Supreme Court has reaffirmed that repeatedly in the last 20 years in Gratz and Grutter, both in the context of the University of Michigan, and then in Fisher 1 and Fisher 2 in the context of the University of Texas. And this line of cases has made clear that it is legally permissible under the Equal Protection Clause of the 14th Amendment for colleges and universities to consider race as one of many, many factors in admissions in order to assemble a diverse student body, as long as there are no racial quotas or racial balancing, if you don't insulate candidates of color from competition with white candidates because of their race, and you don't unduly burden white applicants. So universities can consider race as a plus factor. And the narrow tailoring requirement of the 14th Amendment requires universities to give serious, good faith consideration to all the race neutral alternatives to achieving diversity and race conscious policies, and also to be limited in time. Colleges and universities can't just decide that they're going to have race conscious programs in perpetuity. They have to keep checking back to make sure that the program is still necessary and still narrowly tailored. So Students for Fair Admissions versus Harvard and Students for Fair Admissions versus UNC is another bite at that apple. Edward Bloom, the anti-civil rights activist behind Shelby County versus Holder, which gutted Section 5 of the Voting Rights Act, and Fisher 1 and 2, formed SFFA and orchestrated these lawsuits. And SFFA is also led by Abigail Fisher, who was the plaintiff in Fisher versus the University of Texas cases, and her father. And although the two cases have the same goal, I think there are important differences that we should understand and talk about. And I'll start with the Harvard case. So after losing Fisher, Bloom said that he realized he would need Asian plaintiffs in order to effectively challenge affirmative action. And that's what he did in Harvard. And in the SFFA case, he brought 6 claims against Harvard. The first alleges that Harvard discriminates against Asian applicants. And this is not really about affirmative action. It's about negative action, alleging Harvard intentionally discriminates against Asian applicants and keeps their numbers down. Count 2 alleges that Harvard engages in racial balancing. Count 3 says Harvard uses race as more than a plus factor among many factors. Count 5 says Harvard has failed to use race only to fill the last remaining spots in the class. Count 5 says Harvard has failed to use and consider race neutral alternatives. And count 6 asks the court to overturn this 4 decades of settled law and hold that universities may not consider race at all in the admissions process. And because Harvard is a private institution, the claims were brought under Title VI of the Civil Rights Act of 1964, which the district court concluded meant that Harvard was subject to the same standards that the Equal Protection Clause imposes on state actors. SFFA sought with this case a permanent injunction requiring Harvard to, and I'm going to quote it here, conduct all admissions in a manner that does not permit those engaged in the process to be aware of or learn the race or ethnicity of any applicant for admission. And yes, that means just what you think it means. It is as broad as you think it is. And the district court, it was a win for Harvard in both defending its affirmative action program and defending against the claims of intentionally discriminating against Asian applicants. And then that opinion was affirmed by the First Circuit. In SFFA versus UNC Chapel Hill, which was filed the same day as the Harvard suit, SFFA challenged UNC's top 10% plan, which was similar to the one at issue in the University of Texas. And they brought 3 claims under the Equal Protection Clause in Title VI, and overall alleging that race was the defining feature in the admissions of candidates of color to UNC. For their counts, they allege that 1, UNC uses race as more than a plus factor. 2, that UNC has failed to use and consider race neutral alternatives. And then 3, the court should ban again the use of race or the knowledge of race and awareness of race in the admissions process. And the relief sought is identical to that in the Harvard case, including, again, that total prohibition on the awareness of race. UNC's program was upheld by the district court as well. And so I want to highlight there are some of the key differences between Harvard and UNC that aren't reflected on the face of those complaints. For most of UNC's history, the flagship university engaged in de jure discrimination. They excluded Black, Latinx, and Native American applicants, not only by practice, but also by law. And that impact of the discrimination really does linger on the campus and outside of the campus. Second, as a public institution, UNC really has an obligation to educate all of the state's citizens, including its citizens of color. And importantly, unlike the Harvard case, there is no claim of intentional discrimination against Asian applicants in the UNC case. The plaintiffs in the UNC case are white, but they still argue that high-achieving Asian applicants are most hurt by the program. I think before the Supreme Court, these cases, SFA has really leaned into its argument that neither Grutter nor any acknowledgement of race are consistent with Brown versus Board of Education. And therefore Grutter has to be overruled and the use or even awareness of race has to be outlawed. I think really these cases are important cases. Race continues to matter. It continues to constrain the outcomes for some, the life opportunities for some, and to expand opportunities and outcomes for others. We continue to wrestle with racial inequality in our schools. Black and Latinx students and Native American students remain underrepresented at top colleges. And our nation now is really in the midst of an ongoing and significant backlash against the decades of work to move towards greater racial equity. And the fight against the systems and forces of white supremacy has combined with these underlying fear of what a racially just world looks like and has led to a wave of attacks across issues. And I think that these cases are a part of that wave of attack on even small efforts towards racial equality. And all of this really is reflected in the case, not only in the kind of arguments that SFFA is using to advance their case, but in the arguments that civil rights advocates and the universities at issue are laying out in supporting affirmative action. And then again, even more so in the reply that SFFA has had to those arguments that have been made to support affirmative action. So I'm happy to talk about that more later, but I'm gonna stop there.
Thank you so much for that summary. Let me ask you a question about what you expect the court to do. And if indeed the court says affirmative action violates the Constitution, what are the practical consequences for students around the nation?
Yeah, in terms of what I think the court's going to do, I'm going to continue to remain optimistic until I have no more space left to do that. But it is most certainly an uphill climb. We are in a scary place where we're counting on Justice Roberts, and he doesn't like affirmative action. He has consistently voted to strike it down, and he is very conservative when it comes to the race issues. And we're relying on him, I think, weighing the integrity of the court more heavily. But Dobbs shows us that that's not something that we can necessarily count on. And this is also the first time the three newest members of the court, Kavanaugh, three newest conservative members of the court, Kavanaugh, Barrett, and Gorsuch, will hear a challenge to affirmative action. They never heard any challenges on the Court of Appeals. Civil rights groups were generally concerned about their views on race, and they have given no reason for us not to be concerned. And in other writings and speeches, they've all given us concern about affirmative action. So what could happen? Affirmative action could be upheld. It could be narrowed further. I think over the 40 decades, what we've seen has been kind of a death by 1,000 cuts, where the court's opinion claims to uphold affirmative action, but really narrows it and makes it far more difficult. It also could be that the program at one school is upheld and not the program at the other. Maybe the court relies on the fact that UNC is pushing a get back against a history of de jure segregation and allows them to have a little bit more breath. But if affirmative action is struck down, in this case, I think it could take two forms. First, it could be that just affirmative action programs, the use of race in decisions could be struck down. If that happens, I think colleges and universities will need to really dive deeply into a holistic review process, relying even less on scores and numbers. Their programs will have to look a little bit more like Harvard's, where they're spending an incredible amount of time reading essays and really diving into recommendations and interviews. Most colleges and universities don't have staff large enough to really do that kind of holistic review process. But if all uses or awareness of race is struck down, we are just making our system even more inequitable. And that means that students can't talk about being a member of the Black Student Union as an accomplishment. If they're the president of the Black Student Union, that gets erased from their application because it reveals their race. When I applied to law school, my essay focused on the fact that I lived in Connecticut, in a town where my family was among the first Black families in that community. And our neighbors resisted that. And we had the KKK spray painted on our house and our car. I couldn't talk about that in the essay because that would reveal my race. So I think we'd have to shift to negating, thinking about negating the ways that we view merit, rethink what it means to be engaged in negative action. I think negative action is any way in which race renders an applicant's file less competitive. This includes implicit bias, stereotype threat, class placement, standardized testing, access to mentoring, bias in letters of recommendation, leadership opportunities. We'll have to dig into that a little bit more and try to kind of pull apart the bias and racial inequality embedded into our definition of merit and systems of assessing merit.
Thank you. Let me ask the other panelists if they have thoughts about these incredibly important cases. Hearing nothing, I'm going to turn to Jonathan on two big voting cases. One of them is the court's now familiar assault on the Voting Rights Act, and the other concerns a really interesting and to many people troubling, call it a doctrine, call it a theory, call it an idea about independent state legislatures. Jonathan, tell us about these two cases.
Sure. Thanks, Adam, and thanks to ACS for putting this all together and having us here. I think folks are going to hear a lot of parallels between Professor Archer's summary of the affirmative action cases and what I'm about to describe as far as the court's jurisprudence in the elections context, especially when it comes to the backlash against these structures and policies that we've propped up over the last several decades to remedy historic race discrimination in the voting process, and the way that the court has narrowed those over time and appears set to continue to do so in the next term. So as I think most folks watching this are aware, there's been a lot of election and voting activity at the court in the last couple of years, much of which has been on the shadow docket and emergency orders related to the 2020 election. But in this upcoming term, as you said, Adam, the court is hearing two really critically important redistricting cases on the merits docket, both of which have really significant implications for the administration of federal elections more broadly going forward. The first is Merrill versus Milligan, which is an appeal out of a 3-judge district court panel in the Northern District of Alabama. And the second is Moore versus Harper out of the Supreme Court of North Carolina. So I'll start with Milligan, which, as you said, represents the latest potential threat from the court to the ongoing efficacy of the Voting Rights Act. Alabama has 7 seats in the House of Representatives, only one of which for the last half century has been comprised of a majority of Black voters. That's the case even though Alabama's population overall is more than a quarter Black and only 65% white as of the most recent census. So that means that white voters are substantially overrepresented in Alabama's congressional districts, and the state's Black residents have comparably less opportunities to elect candidates of their choice to Congress. So when Alabama issued its newest congressional map, a challenge was brought by a group of Alabama voters and community organizations challenging that map under Section 2 of the Voting Rights Act. They held a trial in January 2022 before a 3-judge panel, as I said. And notably, that panel included 2 Trump-appointed judges. And all 3 of the judges on the panel unanimously held that the state's congressional redistricting plan violated Section 2 of the Voting Rights Act by unlawfully diluting the votes of Black Alabamians. Not only did the court find that Black voters were disproportionately underrepresented in the congressional map, but also that the other districts improperly cracked and divided what's known as the Black Belt, historic region or community of interest in Alabama, and in doing so had denied the Black residents of the state equal representation in Congress. And so the court ordered the state to create a new districting plan that would have included a second congressional district in which Black voters would have the opportunity to elect a candidate of their choice. It didn't necessarily need to be a second majority Black district. They could have drawn a crossover district where Black voters, in conjunction with white voters or Latino voters with similar political preferences could have elected a candidate together. But the court clearly determined that the map that the legislature had drawn just did not meet the basic requirements of the Voting Rights Act. The state sought a stay of that decision from the Supreme Court in early this year, in I think it was the end of January, which the court granted on a 5-4 vote. In a concurring statement that was a little curious, Justices Alito and Kavanaugh cited what's known as the Purcell principle, arguing that enjoining the maps at that time would be too disruptive to the 2022 elections, despite the fact that at that point that order was issued, the primary was 4 months away in Alabama and the general election was 9 months away. And as Justice Kagan pointed out in her defense, that's the longest lead time before an election that the court has ever invoked Purcell to block a lower court order. So the case is before the Supreme Court now on direct appeal from that 3-judge panel. And on the merits, Alabama is arguing that really anytime someone sets out to draw a majority-minority district, whether it's an expert witness drawing an example map to meet the first prong of the Jingles test, or a state being ordered to do so by a court as a remedy for a violation of Section 2, that is itself, according to Alabama, unconstitutional race discrimination in the districting process. The state is asking the court to eliminate all consideration from race from the districting process, essentially, to make it entirely race neutral. And doing that, if the court adopts the state's position, would really severely curtail Section 2's ability to ensure that minority voters can elect candidates of their choice. It would, just severely limit one of our last remaining tools to prevent against vote dilution in the redistricting process. And it would be the latest blow from the court to the Voting Rights Act, continuing the trend that really began in earnest with the Shelby County decision in 2013, which eliminated the Section 5 preclearance process and continued through all the way to Brnovich last year, which limited the ability of plaintiffs to bring vote denial cases under Section 2 of the Voting Rights Act. Milligan is going to be argued the first week of this term on October 4th, so we won't get a decision before the midterm, certainly. But in any event, the 2022 elections in Alabama and in other states that had Section 2 challenges this year are going forward under the challenge map. Even in Alabama and Louisiana, where district courts have determined that those maps violate Section 2 of the Voting Rights Act. So we're already feeling the impact of the Milligan stay decision on elections this fall, regardless of how it ultimately shakes out on the merits. So that's Milligan. Moving on to Moore versus Harper, it's another redistricting case, but this one carries even potentially further reaching implications on the administration of elections writ large. For some quick just background context, North Carolina's congressional maps have been, for the last decade, among the most egregious partisan gerrymanders in the country, and have been the subject of a lot of litigation. Folks may remember the Rucho case decided in 2019, which was a partisan gerrymandering challenge brought in federal court. And in that case, the Supreme Court held that partisan gerrymandering claims are non-justiciable political questions outside the power of the federal courts to resolve, even though in that same opinion, Chief Justice Roberts did say that extreme partisan gerrymandering does impose a constitutional harm on voters. And as I think Justice Kagan again pointed out in dissent in that case, it's the only time in recent memory, if not ever, that the court both identified a constitutional harm and declared itself completely powerless to do anything about it. Notably, in the Rucho decision at the time, both the 5 members in the majority and the 4 justices in dissent, all of them agreed that state courts applying state constitutional provisions could still serve as a backstop to protect voters against egregious partisan gerrymanders. So nothing in the Rucho decision limited the ability of state courts applying state constitutional provisions to adjudicate congressional maps. Fast forward to now, North Carolina gained a congressional seat as a result of the 2020 census, bringing it up to 14 House districts. And the Republican-controlled legislature of the state drafted a new congressional map that would have given GOP candidates a 10-4 advantage, almost uniformly, despite the fact that North Carolina is fairly evenly divided between Republicans and Democrats. It's pretty close to 50-50 among the voters. Lawsuits were filed in state court challenging this congressional map as both a racial and a partisan gerrymander in violation of the North Carolina Constitution, which has some additional provisions and protections related to free and fair elections that the U.S. Constitution doesn't have explicit clauses about. That litigation made its way through the North Carolina courts up to the state Supreme Court, which ruled 4-3 in February that the maps violated the state constitution and ordered the assembly to draw new maps, and ultimately had a special master do that on behalf of the court. The leaders of the North Carolina Assembly sought a stay of that decision from the court. That stay was denied over dissents from Justices Alito, Thomas, and Gorsuch. So the new maps are in effect in North Carolina for this upcoming election. The thing that makes this case especially notable and potentially quite dangerous to democracy is that the Assembly is making its case now before the Supreme Court on the basis of this so-called independent state legislature theory, which is a sort of totally unfounded kind of fringe idea that asserts that state legislatures have complete unrestricted power to regulate federal elections with no constraints placed on them by state constitutions, state courts, or state executives. This theory is based on a misreading of the Elections Clause of the Constitution, which says, the times, places, and manners of holding elections for Congress shall be prescribed in each state by the legislature thereof, but Congress may at any time by law make or alter such regulations. The long accepted understanding of that clause by legal experts and the court is that the Elections Clause empowers the states to regulate congressional elections through the ordinary exercise of their legislative power, subject to all of the standard checks and balances of the legislative process: the governor's veto, review by state courts, limitations imposed by the state constitution, and implementation by state agencies. Under the independent state legislature theory, as the North Carolina Assembly is arguing, that would radically reinterpret the clause to claim that state legislatures are the only actors who can regulate federal elections at the state level, with no role for the governor or the state courts. That would mean that state courts would essentially lose their authority to rule on legislation, related to federal elections, to see whether they comply with state constitutions or not, including congressional maps. It could also limit or invalidate election policies enacted through direct democracy, like ballot initiatives, including those establishing independent redistricting commissions in places like Michigan. And the most extreme version of this theory would remove the authority of governors to veto election laws governing federal elections, including voting restrictions, and could limit state agencies' abilities to issue rules interpreting or implementing legislation passed by their legislatures. And because this theory only affects rules governing federal elections, it would also require state and local election officials to essentially administer a two-tiered election system with one set of rules for federal elections and a different set of rules for state elections, which would be extremely confusing for voters, chaotic for administrators, who, as we know, are already struggling under the weight of administering elections under extreme public scrutiny and with limited funding. So this theory conflicts with over 100 years of SCOTUS precedent and even contemporary accounts from the founding era. The founders were extraordinarily suspicious of state legislatures exercising too much power over federal elections. And that's reflected in the second part of the Elections Clause, which gives Congress the explicit authority to override state laws that pertain to federal elections. So this case hasn't been set for argument yet. We know it'll come after this November's election. And of course, federal law still contains a decent number of safeguards to prohibit state legislatures from doing things like overturning the results of an election or engaging in blatantly discriminatory election conduct. But the fact that a fringe theory like this is getting a platform and an audience before the Supreme Court and is really being advanced on this stage is, I think, troubling to say the least.
Jonathan, do we have some indications about at least what some of the justices think about this theory? I feel there were a whole series of separate writings, dissents from denial, concurrences and stay applications. And I count as many as 4 justices who seem to be sympathetic to the theory.
Yeah, I think that's right. As I said up top, there's been a lot of election activity at the court lately. And Justices Gorsuch, Thomas, and Alito have all either endorsed or indicated support for some version of this theory, mostly in dissents or concurrences in the 2020 election cases. Justice Kavanaugh, in the decision denying the stay in Moore, didn't embrace the independent state legislature theory quite as fully as the other three that I just mentioned, but at least indicated an openness to consider it. And we haven't really heard from Justice Barrett on this issue yet. Chief Justice Roberts is an interesting case here. He wrote the lead dissent in Arizona Independent Redistricting Commission, which touched on this issue. And in that dissent, his position seemed to be at least sympathetic to the idea that legislatures, mean legislatures and not an independent redistricting commission. Whether his views are limited to that context or are more broadly applicable here is not super clear. Based on the way that he voted in some of the 2020 election cases, I think he is skeptical of some of the more extreme versions of this theory. But we really don't know exactly where he would come down. And as I said, Justice Barrett really hasn't weighed in one way or the other.
And as you noted, his majority opinion in Rucho sure seems to cut in the opposite direction in saying that state courts do have a role to play here.
That's right.
Well, that was very helpful. Thank you. Thoughts or comments on these election cases?
If I can jump in, I just wanted to, it's a thought. I think that Jonathan is even understating how scary these cases are. They're not getting enough attention based on the impact that they could have. I know civil rights advocates across the spectrum are concerned about the voting cases. A disparate impact really hangs by a thread right now, and these cases could clip the thread not only when it comes to voting, but in the context of the Fair Housing Act or Title VI. And so this case really has an impact to potentially do a lot of harm. And so I'll certainly be looking at that closely to see how it impacts other areas. And then also just the impact on voting itself. It shows that all of these civil rights laws that we believe are protecting our civil rights and civil liberties really work together. All the pieces are important. And so we got rid of Section 5, which opened this floodgate to legislation that is suppressing the right to vote. We're just holding on and challenging that with Section 2, not as powerful as Section 5 in many ways. And now Section 2 is at risk. And the impact of this inequity in voting causes real harm to already vulnerable populations. They're losing their right to vote, and then their elected officials are attacking their privacy and bodily autonomy, their First Amendment rights. So it is all really scary and all deeply connected.
Yeah, I think that's exactly right. And, we are already feeling the impacts of these cases even before they've been decided, right? Voters in Alabama and Louisiana will be voting in districts this fall that courts have already determined are unlawful. And, the district court in Alabama in particular, it's a really fact-intensive decision. They had, I have it in front of me, they had over 1,000 pages of briefing, more than 350 exhibits. The transcript of their hearing was more than 2,000 pages. They really, they really dug into the facts on the ground, the racially polarized voting in Alabama, and the way that legislators have kind of carved up the Black Belt and denied their Black citizens equal representation in Congress for at least half a century, if not more. And so, those are the maps that they're going to be voting in this fall. And so, the impact is already being felt. And if the court adopts Alabama's argument in the Milligan case, and says you can't consider race at all when you're crafting remedies, applying statutes that were designed to combat racism, I don't know how you do that. I don't know how you remedy problems of historic race discrimination by pretending race doesn't exist.
Adam, I had a question to these two folks actually about Deborah's case, the Harvard case, and also the case from Alabama that Jonathan talked about. Do either of you, I mean, it seems to me that this is an opportunity for the court to really sort of limit the use of race completely. Do you anticipate that both these cases will rise and fall together, or can you imagine the court saying, okay, we're going to continue to let race be used in a limited way in one and not the other?
That's a good question. I think what maybe the key distinction between Milligan and the affirmative action cases is that Milligan is really sort of squarely focused on the VRA. It's a statutory interpretation case, which may give some of the members of the court who are a little more hesitant to go to the extremes, or who want to take things a little more slowly, may give them an opportunity to issue a narrower ruling. I'll be interested to hear what Deborah has to say about the affirmative action cases. But since those I think are more focused on issues of constitutional interpretation rather than statutory, I think that it's harder for them to make a narrower ruling in that context.
I agree with you 100%. The fact of the Voting Rights Act makes it a little more difficult. But here in the affirmative action context, it's a constitutional interpretation. Diversity was never the strongest argument that we had in defense of affirmative action, but Bakke left us with that. And so we've worked with it, but it is a tough road. And I think that for many justices on the court, they've already expressed their goal of having as much color blindness and race neutrality as they can, despite the fact that we live in a world and within systems that are anything but colorblind or race neutral.
And I think the other thing that comes to mind is that we have seen a Voting Rights Act case more recently, just last term, with 8 of these 9 justices, where the majority in the Brnovich case did show a willingness to kind of chip away at Section 2 rather than issuing a really sweeping decision. But as Deborah said, 4 of these justices at least have not ruled on an affirmative action case before. And so we don't have as much of a roadmap as to how quickly they want to go on that issue.
And let's be wary of the chipping away. I think that this court does their work over multiple terms. And so the fact that it will only be a small chip doesn't mean it's the last chip. We've seen that with—
There's not many chips left.
That's right. With affirmative action, there aren't many chips left. And with reproductive justice, they just took a big sweeping chip, but they had been chipping away over time.
Let's turn to Kent and another big case. This may strike some of you as a deja vu. You remember Masterpiece Cake Shop, the question of whether a baker in Colorado with religious objections to same-sex marriage could decline to bake a custom cake for a same-sex couple. And the court didn't give us a definitive answer, but now they're back. And with only slight variations, it strikes me as the same case. Am I right about that, Ken?
Yeah, in fact, that was now you buried my lead, or you took my lead. I'm here to talk about the 303 Creative case out of Colorado. But let me first start by saying it's an honor to be on this panel, and thanks to you, Adam, for doing this, and thanks to Russ and ACS for inviting me. Now, this is a case about whether a company can assert a First Amendment interest that will exempt it from anti-discrimination law. So 303 Creative is the party here, and it's a Colorado-based web design company created by a woman named Lori Smith. Ms. Smith says that she would like to create websites for weddings, but that she says doing so for same-sex couples would be inconsistent with her political and religious beliefs. But Colorado has a statute prohibiting her from discriminating on the basis of sexual orientation. So she sued, asking for a pre-enforcement declaration that the Colorado's anti-discrimination statute would violate the First Amendment if applied to her and to the company 303 Creative. Now, there are lots of vehicle problems in this case. 303 Creative has never created a wedding website, for example, but the court reached out and granted cert nevertheless, I think, as Adam implied, in order to decide the issue that was left undecided in Masterpiece Cake Shop. And as Adam said, Masterpiece Cake Shop raised these same issues. That was decided in 2018. The lawyer for 303 Creative is Alliance Defending Freedom, which was also the lawyer representing the bakery in Masterpiece. Now, the baker in Masterpiece claimed that the wedding cakes that he was making for weddings were expressive, and much of the oral argument in that case was spent in exchanges with the justices asking different hypotheticals about whether other wedding-focused artisans were engaging in communicative behavior. Was the chef at the reception engaging in expression? Was the hairdresser? Was the makeup artist? And that case as Adam said, was decided on different grounds. And in an opinion by Justice Kennedy in his last term, the court decided that the baker had been a victim of religious animus by the administrative agency enforcing Colorado law. But the difficulty of whether the cake was expressive lingered in subsequent analyses and was not decided. Now, ADF, the lawyer here, has solved that particular problem in this case, because here there's no doubt that a website is communicative. ADF's brief compares 303 Creative to other artists and quote, like painters, photographers, writers, graphic designers, and musicians. And its brief says that when artists are forced to speak messages that violate their deeply held beliefs, it violates the First Amendment promise of individual dignity and choice. Now, the state, for its part, says this is not a case about artists or even speech, but a case about the marketplace. Companies doing business in the marketplace are public accommodations, and they have long been required to take all comers. The state argues that the case is not about communication at all, but about whether a business can refuse service to people based on protected characteristics. In other words, the state says this case is about conduct, not speech. Now, the reason this case is interesting and difficult is that difficult to predict is that the case comes as a First Amendment matter at the intersection between two conflicting lines of cases and principles. On the one hand, the court has indeed held that nonprofit associations and groups, when engaged in communicative or associational activity, may assert a First Amendment right to be insulated from anti-discrimination laws. You'll remember the South Boston parade case from 30 years ago, Hurley, and the Boy Scouts case called Dale in the late 90s, in which case, in both cases, the court ruled that those unincorporated associations or those nonprofit groups could assert a First Amendment defense to an anti-discrimination claim, at least with regard to sexual orientation. On the other set of principles and cases are the fact that come from the fact that companies have been held to non-discrimination principles of public accommodation laws for centuries. When you enter the market, you can't discriminate. That's been the assumption. And the court has held in a number of situations that there is a significant interest, governmental interest, in fighting against discrimination in the workplace and elsewhere. You've got the Bob Jones case, you've got the J.C.'s case, you've got Piggy Park, the 1960s. And even Justice Kennedy said this in Masterpiece, but in dicta. And moreover, there are myriad examples of companies being required to speak or not to speak in ways that are essential for the marketplace to run. The First Amendment has not been thought to have much to say about securities disclosures, for example, or mandates that companies post EEOC notices in their workplaces. So if the choice in this case comes down to between these two competing principles, an increasingly libertarian view of the free speech clause on the one hand, and the longstanding regulatory limits on businesses necessary for the market to work, I have little doubt which way the court will decide. The court is expanding both its understanding of what speech is and its protection of it. And moreover, even though this case is facially a speech case and not a religion clause case, the case fits comfortably in the court's broadening effort to expand religious protections for religious people, associations, and businesses, especially when those religions are evangelical and mainstream. The court is increasingly solicitous of religion claims, whether to pray in the middle of a football field, gain financial support for religious schools, or insulate companies from societal anti-discrimination commitments that other companies must obey. Now, as I mentioned, Masterpiece Cake Shop failed to reach the merits of the speech claim in that case, and I thought at the time that we dodged a bullet. That if the court had ruled on the speech claim, that it would have ruled in a way to protect the baker's right to discriminate. And the religion clause outcome was in effect a compromise. Breyer and Kagan joined Kennedy's majority opinion in that case. But that court had Kennedy and Ginsburg on it, and this one has Kavanaugh and Barrett on it instead. And I think if the court reaches the speech question, it is likely to decide it to protect the business's right to discriminate. I filed a brief in the case along with the partnership of Daniel Rubens, who's in the appellate practice at Orrick. Now, I filed in my own name as amicus, ostensibly in support of neither party, and I'll explain why. We argue that the court should not reach the merits in this case either. We're trying to dodge a bullet here too. The entire presumption of 303 Creative's claim is that Colorado's anti-discrimination law violates its constitutional interest. The name of the company is in the caption of the case, but the company does not have religious beliefs. Lori Smith does. Smith created the business in a legal form called an LLC, a limited liability company, in order to separate herself from the company for purposes of liability, finances, and the like. The company is its own legal entity. It's its own legal person. So Smith chose this legal form to separate herself from the company and derive significant benefits and protection from doing so. My brief argues that Smith cannot separate herself from the company when it suits her and then project her belief onto the company when it suits her. Because the entire case is premised on Smith's beliefs and not 303 Creative's beliefs, and I think they're different, we argue that the case should be dismissed or remanded. I don't know if we'll be successful in enticing the court to avoid the merits, but if they reach the merits, I'm not optimistic about the state's chances.
And do you think the nature of the discrimination will play a role in the court's thinking? I remember in the Masterpiece Cake Shop argument, the ADF lawyer had a particularly hard time with the question of, well, what if the business owner wants to discriminate against an interracial couple? What if race discrimination, not discrimination against gay and lesbian people, were an issue? And didn't really have a satisfactory answer to that. So I wonder whether the other aspect of this clash, we've talked about the expressive rights or not of the company, but whether the nature of who is being discriminated against will figure in the court's thinking.
Right. The ADF lawyer did not have a good answer to that. And of course, the court doesn't really have an answer to that either. I think this is one of the reasons why and I always wanted Justice Anthony Kennedy, to be more explicit in his cases protecting the rights of LGBTQ people, to say that the state, that it's a suspect class. He never explicitly said so. And I think that leaves a void, because now it's harder for the state to say we have a compelling interest to fight against discrimination on the basis of sexual orientation. Now we know that there's this case Roberts v. JC's out there, and in that case the court said that a private organization, JC's, cannot discriminate on the basis of sex. And yet we have these other cases like Dale saying that they can discriminate on the basis of sexual orientation. And really the best way to understand these, I think, is that the court has articulated a heightened scrutiny for sex and race, but not clearly so with regard to sexual orientation. So I think this is one of those situations where Kennedy missed an opportunity. If he really believed in sexual orientation being a suspect class, he should have said so explicitly in either Obergefell or in Masterpiece Cake.
Other thoughts on this interesting case? All right, let's turn to Winona. And it might appear that there's a theme running through many of these cases. Let's talk about the Indian Child Welfare Act and a challenge to it.
Thank you so much, Adam. It's a pleasure to be here. And so I'm here to talk about a case that will be argued November 9th before the Supreme Court, called Holland versus Brackeen. And that case is a challenge to the constitutionality of a statute called the Indian Child Welfare Act, or ICWA. And first, I'd like to provide a little bit of background on ICWA. The statute was passed by Congress in 1978. And at the time, there was a recognition that between 1/4 to 1/3 of all Native American children were being torn from their families, removed from their families, and placed into foster care or adoptive homes. And so furthermore, 90% of those children were being placed into non-Indian homes. And so there was a wholesale removal of Native children. And also this was largely the result of ignorance and contempt on the part of both caseworkers and the courts, including both public and private agencies that worked on these child welfare matters. And so this caused widespread harm for Native children across the United States, and also even threatened the very continued existence of Indian tribes in the United States. And so furthermore, it's also important to note that this also threatened the ability of the U.S. to live up to its trust responsibility to tribes, which of course arises in large part out of the nearly 400 treaties that tribes have entered into with the United States, where the U.S. has committed to protect Indian tribes. And so, so Congress responded to those facts in 1978 by passing ICWA. And ICWA itself, as a statute, provides for the stability and security of Indian families and tribes. And what it does is it protects the best interests of Indian children, and it's recognized around the country as the gold standard for child welfare. In addition, what ICWA does is it provides both procedural on the one hand and substantive on the other hand protections in child custody proceedings involving an Indian child in state court. And so some of those aspects of the statute at issue include the fact that there's an obligation of state courts to give notice to Indian tribes when there are involuntary proceedings seeking the foster care placement or termination of parental rights of a child, an Indian child. There's a requirement for active efforts to provide remedial services and rehabilitative programs to prevent the breakup of an Indian family. There's also placement preferences. And those placement preferences require that where there's child custody proceeding, the first preference for placement is with a member of the child's extended family. The second preference is for placement with the child with a member of the child's tribe. And the third preference is for placement with other Indian families. And of course, there's also an opportunity for courts to depart from those placement preferences for good cause. But in addition, it's important to note that even though ICWA was passed and provided for these protections, it's absolutely still needed as a statute, that Native children are 2.5 times overrepresented in state foster care relative to their existence in the US population. And so absolutely, we continue to see disproportionate involvement of Native children in the state foster care system. And so ICWA, the statute, has been subject to a variety of challenges by parties and organizations that have been seeking to undo its protections. And so this case of Holland versus Brackeen is the latest and most successful example of that longstanding effort. And so the Brackeen case originated with a petition that was filed by the state of Texas and 3 non-Indian couples. It was, interestingly, it was filed in the Western District of Texas and heard by Judge Reed O'Connor, who frequently sides with cases involving the Texas Attorney General. And he did conclude that ICWA was unconstitutional. But the case was appealed, and it was the decision was reversed by the Fifth Circuit Court of Appeals. Then the parties sought review before an en banc panel of the Fifth Circuit. And in that en banc decision, which was a 325-page decision, there was a fractured opinion in which there were a number of different, a long variety of different legal issues addressed with a split of opinion related to many of those issues. And so the case has been appealed to the US Supreme Court and has been briefed and is set for argument in November. And so the main legal issues include the following. The first that I want to point out is standing, because it's important to note that that in fact there's a strong argument that in fact the petitioners, the Texas and the non-Indian couples lack standing because there's no redressability. That in fact, this is a case in the federal courts in the US Supreme Court, and it's not binding, that the existing opinions are not binding on state court proceedings, which is where the ICWA is actually applied. And in addition, there's an argument that there's no standing for the non-Indian couples because there's no injury in fact experienced by them, that their cases, their individual cases have actually ended and there's been adoptions. And so there's that argument as well. So if the case certainly could be dismissed for lack of standing, but in addition, if it's not, and the court reaches the merits of the arguments presented before the court will have a variety of different issues to address. And one of those is whether Congress has authority to pass the Indian Child Welfare Act. And so this issue relates in part to Congress's authority under the Constitution's Indian Commerce Clause, as it's called, which vests Congress with authority to regulate commerce with the Indian tribes. But also at the same time of the ratification of the Constitution, the contemporary dictionary definition of commerce included intercourse with tribes. And so it was widely understood that Congress had the authority to regulate all intercourse with tribes, and that its authority was not limited purely to trade, for example, which would be a very, very narrow interpretation of commerce. And so that's important to note. And furthermore, there's also additional basis for Congress's authority in Indian affairs. There's also War and Peace authority and treaty clause authority for Congress's work in Indian affairs. And in fact, since the nation's formation, the United States has long had policies which have specifically applied to Indian children in Indian country, both harmful policies and some policies which have been beneficial, like the Indian Child Welfare Act. So it's long been a subject and concern of Congress. In addition to that, the challenge to Congress's authority, there's also an equal protection challenge. And the equal protection challenge is rooted in the presumption that this is a race-based statute that requires strict scrutiny analysis. But we also have precedent in the field of federal Indian law based on a prior U.S. Supreme Court case called Morton v. Mancari, which stands for the holding that, in fact, when Congress legislates in the area of Indian affairs, it's legislating based on the political status of Indians and not based on their race, that Indians have a unique government-to-government relationship with the federal government. And furthermore, they are separate sovereigns and they have their own membership criteria. And so it's important to note that that based on Morton v. Mancari, the Supreme Court has held that when Congress legislates in the area of Indian affairs, that legislation is subject to rational basis review. And it's upheld as long as the special treatment for Indians is tied rationally to the fulfillment of Congress's unique obligations to Indian tribes and to Indians. And so that's a really important principle in federal Indian law. And if the U.S. Supreme Court were to alter this approach to analyzing and evaluating the lawfulness of a legislation in Indian law, it could certainly have much broader ramifications for other aspects of Indian law beyond the Indian Child Welfare Act. And then in addition, some say that because the Indian Child Welfare Act applies to an Indian child, even if they're not enrolled in a tribe, that's a race-based distinction. But at the same time, an Indian child under the statute is defined as someone who is eligible for enrollment and who has a biological parent who is in fact enrolled. And so it is absolutely connected to their political status, and the concept of parentage as being relevant to citizenship is relevant in US citizenship as well. And so it's not foreign to this concept. And then in addition, there are two other important arguments being presented before the court. And one is that the Indian Child Welfare Act violates the anti-commandeering doctrine. And so there's an argument that Congress is issuing direct orders to the states via the Indian Child Welfare Act. But another perspective is that the Indian Child Welfare Act is not ordering state officers to administer or enforce a federal regulatory program, but rather it's applying a federal standard and via preemption must apply in state courts. And then finally, another argument that has been made by the non-Indian couples in the state of Texas is that Indian Child Welfare Act violates the non-delegation doctrine, since there is a provision in the statute that recognizes that tribes can alter and adopt their own unique placement preferences that may differ from the statute. And at the same time, however, another perspective regarding this non-delegation argument is that there is no delegation toward tribes. It's a recognition of tribes' inherent sovereignty to develop their own placement preferences using their own sovereignty. And so I think it's really important to note that this Supreme Court case it could have huge ramifications for Indian law, both within the specific context of child welfare in Native communities, but also in the much broader context if there's new law that's generated by the court that reverses the precedent of Morton v. Mancari and applies strict scrutiny to statutes and Indian affairs. That could certainly disrupt the very foundation of so much of federal Indian law in the United States. So it's an extremely important case.
You've persuaded me that with the 16 different issues in this case, this will be a challenge to write a newspaper article about.
I hope that you do, regardless.
The court has seemed to be very active in Indian law cases in the last couple of terms, and it seemed to take a U-turn in one of them. Do you have a sense of where the court is as a general matter on these issues these days?
Well, I think it's important to take note of the makeup of the court, since we have seen some, changes with the addition of Justice Ketanji Brown Jackson, and also with Amy Coney Barrett being added to the court. And so I think that we have in Amy Coney Barrett and Chief Justice Roberts and Justice Thomas, Justice Alito, and Justice Kavanaugh. We're speaking to folks where it's very important to, I think, make textual arguments about the Constitution and to also argue about the broad power of Congress and the broad understanding of the concept of commerce in the Indian Commerce Clause. We also have justices who have shown a commitment to understanding more deeply Indian law, such as Justice Sotomayor. And of course, we have the very important swing vote and the decisions that have interpreted Indian treaty rights and affirmed them by Justice Gorsuch. And so they certainly could play an important role, Justice Kagan as well. I think that overall, though, we have a Supreme Court makeup that does create significant cause for concern in terms of whether we will have the necessary votes to broadly protect the Indian Child Welfare Act. And so I think it's very important that we also focus on the standing issue in particular as well.
Thank you. Shobha, tell us about United States against Texas, which I feel like could be the name of half the cases on the docket.
Thank you, Adam. And I also want to express my thanks to ACS for inviting me. I'm also reflecting the last time I was on a Supreme Court preview or review panel. Sitting next to me was the late Walter Dellinger, and I'm thinking about him today as well. I come to this panel as an immigration attorney and scholar, and for the last many years, I've been steeped in research on this question about the role of prosecutorial discretion in immigration law. And as Adam mentioned, I'm here to talk about US v. Texas, a case, many names can be associated with US v. Texas, but this particular case is a challenge to a memorandum titled Guidelines for the Enforcement of Civil Immigration Law. And this is a guideline that was issued by the Secretary of Homeland Security last September and is commonly known as the Mayorkas Memo. So as just some background, the Mayorkas memo provides guidelines on prosecutorial discretion, which in immigration refers to how and whether the agency or the Department of Homeland Security will take enforcement action against a person or a group of people. So to illustrate, when DHS chooses to not file a legally sufficient charging document against an undocumented mother who is a primary breadwinner for her family, it is choosing to exercise this discretion favorably. The Mayorkas memo reaffirms the legal authority and the principles of prosecutorial discretion and goes on to list 3 priorities for immigration enforcement. Enter in US v. Texas. The state of Texas and Louisiana filed a lawsuit in the Southern District of Texas. Their claim was that the Mayorkas memo is contrary to law, arbitrary and capricious under the Administrative Procedure Act, and procedurally irregular under the same. In June of this year, Judge Tipton of the district court agreed with the states and vacated the Mayorkas memo in its entirety. The Biden administration filed an appeal and an application for a stay with the Fifth Circuit Court of Appeals. The appellate court denied the stay. And then in July, the Biden administration filed an application to the US Supreme Court, asking it to stay the order issued by Judge Tipton. The Supreme Court refused to do so and instead granted certiorari, scheduling oral arguments for the first week of the December argument session. Justices Sotomayor, Kagan, Barrett, and Jackson would have granted the stay. So the court has asked the parties to answer 3 questions. First, whether the state plaintiffs have standing to challenge the Mayorkas memo. Second, whether the Mayorkas memo is contrary to 2 provisions in the immigration statute or otherwise violate administrative law. And finally, whether another provision of the immigration statute, known as 1252F, prevent the district court from vacating the Mayorkas memo. So I have a lot of reactions to even where we are before the court has even heard this case. Both the challenge and the outcome really represent a striking departure from the history, the law, and the application of prosecutorial discretion in immigration for more than a century. There is nothing remarkable about the Mayorkas memo, and yet the lower courts have singled it out. To illustrate, both the district court and the Fifth Circuit took issue with the portion of the Mayorkas memo that instructs officers to conduct an assessment of the individual and the totality of the circumstances before determining whether someone is a priority. But that is not different from how prosecutorial discretion has or should function for decades, case-by-case determinations based on individual circumstances. Further, the legal foundation for prosecutorial discretion is outlined in the Mayorkas memo and companion considerations memo and is crystal clear, guided by sections of the immigration statute, Supreme Court jurisprudence, and regulations. The 2 statutory provisions the courts seize upon are 2 detention and removal statutes. One pertains to the mandatory detention of certain criminal non-citizens, and the other is focused on the detention and removal of those who have been ordered removed. These 2 statutes have been part of the system for a long time, and also long understood to have discretion built into it, meaning shall has never meant shall. The court's procedural conclusions are also striking, at least the lower ones, because they really depart from the idea that guidance documents like the Mayorkas memo have long been treated as such, general statements of policy exempt from rulemaking. There are at least 12 documents from the former Immigration and Naturalization Service and now DHS that resemble the Mayorkas memo, but have been used and operated as guidance documents. I'm also surprised by the jurisdictional question. The Mayorkas memo is department-wide, but it focuses and opens that it is limited to the apprehension and removal of non-citizens. And yet the focus of this litigation is on 2 detention statutes. Finally, I really worry about the allocation of power. This lawsuit has now called a question for the first time. Who controls the direction of prosecutorial discretion? Courts or the executive branch? So let me just end this preliminary portion by asking a question that I get asked often since this litigation started. Is prosecutorial discretion dead? Well, the short answer is no. Prosecutorial discretion is inevitable because of the agency's limited resources. There are also a number of existing memoranda in effect, some related to the fortification of DACA, others related to immigration enforcement in protected areas like near schools or places of worship. Even Judge Tipton acknowledged that individual grants of prosecutorial discretion are valid. And even the agency, the Department of Homeland Security, has stated that notwithstanding the vacatur, prosecutorial discretion decisions can be made on an individualized basis. But as Jonathan alluded to when talking about the cases he covered, I think we're feeling the impact of this litigation before we even have an outcome. I am concerned by a current landscape where we do not have a single guideline on prosecutorial discretion. What kind of message is that sending to immigrants and families who in the last administration were guided by no specific priorities and a so-called open season on immigration? And what is the message of this litigation sending to local ICE officers and offices who may believe they're in a different landscape now that the Mayorkas memo currently does not apply? Thank you.
So am I right in thinking that in joining this memo, itself an interesting phrase, in the interest of doing away with prosecutorial discretion, it actually increases prosecutorial discretion. It just pushes it down to the local level.
You could say that without having guidelines from the top that help to inform discretion as it trickles down. You end up in a situation where you're going to have discretion because of limited resources, but there are no guidelines for officers to hang their hat on. So I don't know that it's more discretion, but it's certainly more decentralized.
Yeah. So I encourage folks in the audience to put their questions in the Q&A. I'm going to turn to one of them, but then I'm also going to ask the panelists, having heard so much about a set of cases that seem unusually unified. I mean, there are themes that run through them this year, to think about whether they have concluding thoughts. But first, let me ask this good question of Kent, if I can find it. How does Professor Greenfield's LLC argument fare against Hobby Lobby on the rights of owners in relation to their corporate form undertaken? That is, the Hobby Lobby case seemed to say that, at least in the context of the Religious Freedom Restoration Act, corporations do have at least statutory rights.
That's right. And that's the first cut at a distinction, is that wasn't a constitutional case. It was a Religious Freedom Restoration Act case. And the definition of legal personhood might have different implications. But I think our core argument in our brief is really, you just can't import into constitutional law very contested ideas and notions from corporate law. In corporate law, one of the things that's quite certain is that there's a difference between investors and the company, and you can't just complete the two when it comes to religious views or free speech views. Now, the Hobby Lobby did implicitly equate them, but it's a statutory case, and they didn't grapple with the notion and the question that we're urging them to grapple with.
Here's another good question. It's not a question about anything on the docket yet, but it's a pending request that the court revisit the insular cases about people living in United States territories and having fewer rights than the rest of us. I don't know if anyone here has thoughts on this, but I'd love to hear them if you do. Do you think the court will grant cert? What do you think the ramifications of this case will be if the court decides to take the case? And what do you think of the Biden administration's stance in the cases? I realize this comes a little bit out of left field, but I wonder if anybody has thoughts on these cases.
Yeah, I'm happy to jump in. I don't think I'm familiar enough with the I think it's the Fitu-Semanu case to know
Yes,
whether
right.
the court will take it up or not. But on the question of the insular cases, I think it's pretty easy to say, the insular cases are deeply racist and a stain on the court's history and reputation. I think that the court should take the earliest opportunity while it's in the business of overruling cases. It might as well throw out that group of cases, which are from the turn of the 20th century following the Spanish-American War, and have had really devastating impacts on American territorial residents in places like Puerto Rico and Guam and American Samoa. And just, if you read them, they're kind of staggering. They are premised on the social science of the day that is just kind of, there's no other word for it, just blatantly racist and insulting to, people of color. And, I think, deeply disappointed that the Biden administration didn't take the opportunity to even, regardless of their position on whether the court should take up this particular case, that the Justice Department didn't disavow relying on the insular cases, I think was a huge missed opportunity.
Mm-hmm. Back to Shobha for a second. Why do Texas and Louisiana care so much about the Mayorkas memo? What's their real goal?
Well, I might be in a different business if I had the real answer, but what I can share is there is a broader theme, right, or recurrence rather, of states, including the state of Texas, bringing challenges against the Biden administration with regard to their immigration policies. So we saw that this, for example, with Remain in Mexico recently. The stated concern that Texas is making in this particular case is their own injury and the ways in which they are being harmed because of the Mayorkas memo. And they are including, for example, costs to the state with respect to custody of those who have criminal histories and are non-citizens, as well as the costs of having to provide public education to their children. Now, the Biden administration has argued that this is speculative at best. The Sixth Circuit believes it's conjecture. And it's hard to know if it's a anti-President Biden's immigration policy agenda or a true belief in actual injury, or a little bit of both.
Thank you. A question for Deborah, I think. The question is, do we think Justice Jackson's recusal from the Harvard case will have any impact on the decision in that case? Is it possible for the court to have different outcomes in the Harvard and UNC cases, or will the conservative supermajority make that a null issue?
Yeah. So that's an interesting question. The cases were initially joined and were going to be argued as one, and then they were separated. And some people suspect that is because Justice Jackson was recused from the Harvard case, but not the UNC case. So this does give her an opportunity to sit and hear the UNC case. Whether or not that is going to affect the outcome, I think is a different question. As the person who asked the question indicates, the supermajority on the court, I think, means that her impact will really be felt in the discussions that we won't hear between the justices, and she offers her perspective, and also in the dissent I hope she writes if the court seeks to strike down affirmative action, laying out the case for affirmative action and the realities of race in America.
Thank you. I'm going to return to Kent because your amicus brief apparently has caused some real head scratching, or at least a jump off for discussion. How does your argument fare against the New York Times exercising its First Amendment free press rights? So whatever the answer is, Kent, the New York Times' rights ought to be maintained, right?
Absolutely. Well, you know, I actually, I'm a big believer that corporations may have First Amendment rights, not just the New York Times, but other corporations too. And in fact, I'm an outlier in some respects about this with, among my more progressive corporate law colleagues and constitutional law colleagues. I even wrote a book, corporations are people too, and they should act like it. And my argument has long been that there are instances in which corporations like the New York Times, like others, can have a role in public debate. But my point here, and I made it also in the Masterpiece Cake Shop case in a brief that was joined by several dozen corporate law professors, is that that you can have corporations having First Amendment rights, but they can't be just a projection of the interest of the shareholders or investors, or in this case, the member of the LLC, which is what you call the investor in an LLC situation. So, if corporations are persons, are legal persons, and they're separate from their investors, and they can't, and in this case, Lori Smith chose to separate herself from the company for reasons of liability, for reasons of finance, and she can't choose to separate herself when it comes to finance and liability, but then say that we're the one and the same when it comes to religious freedom and religious interest. Now, and so what we're saying is that the company might have religious interest, but that has not been in this case so far. It hasn't been determined or litigated below, and so at the very least, the court should remand for further consideration of that question.
I'm sorry to say we've just about run out of time. I thought this was an exceptionally rich discussion of really what we've demonstrated is it's quite a term. And I also compliment the audience. We didn't get to all of the questions, but the ones we got to were so sharp and smart. So if we were here in person and maybe even virtually, please join me in thanking this terrific panel. And unless someone from ACS has concluding remarks or thoughts, thank you for being here.